So, welcome to class. This is going to give you some sort of indication as to how we will be proceeding this semester with lecture materials. Now, typically, I would be uh, standing in front of you, introducing the topic of the day, but in an online environment, I can't necessarily replicate that. However, I have created prezzies for each topic that are going to give us some sort of overview of each topic as well as integrate videos and other materials that may be of use in understanding what are sometimes complicated legal issues. So today's topic is basically a general overview of this entire course. As you know, in the hospitality industry, about 70% of the decisions that you make on a daily basis are affected by the law. So, for example, you'll see that not only are you supposed to view the law from a human resources standpoint, i.e., the relationship you have with your employees, but you also must look at the relationship you have with the federal government, the state government, in our case, the state of Michigan, and local municipalities, including the city of Grand Rapids, Kent or Ottawa County, etc. So we're looking at HR concerns, governmental regulation, and we also focus on things related to contract law. Essentially, in the hospitality industry, you're going to be buying goods, whether those are pieces of furniture, food product from distributors, beverage from distributors, or basically anything that could create the proper ambiance or atmosphere for your guests. And then you will take that product, which you purchased contractually, and modify it to something that can be sold to the consumer. On that end, you'll have another contract where you're making representations to guests about the quality of your product, about the amenities that will be offered, and about the expectation of the guest's behavior while they are with you. Now, that behavior is a topic we will get into throughout the semester. But know that my primary reason for conducting a lecture of an introductory nature is to let you know from day one that I hope you can go through your life without ever being sued. Your industry is unfortunately what they call a litigious industry. What that means is that you have a lot of money going around, and when customers enter your facility, they expect to be safe. Now, that is not always the case, so they may become injured. Customers may incite violence with other customers or injure them through their negligent behavior. And then you have the whole issue of employees and their safety in the workplace. Now, many of those issues are related to human resources, and this class is certainly not a human resources focused course. But we do encounter certain HR dilemmas that I will address at appropriate times. Now, something to be especially cognizant of is that the law with each new political cycle, with each new year, becomes increasingly complex. And this magnitude, this complexity, is not even fully understood by attorneys. So, what I'm asking of you in this course is not to be an attorney. I would never ask that of you, and if you want talk to me about my experience, please feel free to contact me or come and see me in my office. However, I do want you to start thinking like an attorney. My uncle is a partner at Miller Canfield, one of the larger law firms here in Michigan. And when I told him that I was going to be attending law school, he said, "John, are you sure you want to do that? Because it's the worst possible job you could have." And I said, "Well, I don't know. I haven't really thought about it." But he did add, "It is, however, the best education that you can receive." To that end, I hope by the end of this course that you begin to see your responsibilities to others in a different way. I hope that you begin to notice things in your everyday lives that could potentially be dangerous or that could be safer. And so, what we're going to talk about in this class is basically common sense principles in attempting to adhere to the law. So, again, please concede you're never going to be an attorney unless you really, really want to. And I would never ask you to be one, but I want you to think like one to the best of your ability. One other dilemma deals with the magnitude of the law. So, what we're looking at in terms of course material week to week is an endeavor that takes years in law school to complete. I'm given one semester with you. So, for example, today we'll be talking about the foundational aspects of law, preventative management, ethics, and all three of those topics could be an individual semester-long course in law school. Next week, we'll begin discussing the government agencies that regulate you in this industry on multiple levels. Again, federal, state, and local. That, in and of itself, are year-long courses. Constitutional Law 1, Constitutional Law 2, Foundations of Government. So all we can really afford are brief looks into these areas of the law. I would advise you that if a particular area jumps out at you as being interesting, to immerse yourself in that area because there will be plenty of knowledge for you to gain in doing so. I look at this simple three-letter word, the law, and think to myself, how unassuming of a word. When you really begin to look at the law, you'll see that it follows you around like a little lost puppy. And no matter how you try to shake this thing, whether you want to keep it or not, it's going to be there by your side for as long as you're here, or as long as it's here. And I'm willing to bet, as it pertains to the law, that it will be around for much longer than you or I. So what we need to get out of the way at the outset are the stereotypes associated with the law. Now, during a live action class, I would be engaging in dialogue with you and asking you to do sort of a Freudian word association. So, for example, when I say the law, what's the first thing that comes to your mind? Just the first thing. I say law, and you say, maybe you said rules. Maybe you said police or justice. Maybe you thought of courts. If I say law, you say, and at this point, let your mind go to a darker, more stereotypical place, because oftentimes when I say law, you think lawyer. And if I say lawyer, well, then a whole spectrum of emotions may come up depending upon your experience with this profession. It is not outlandish, and nor will I be offended if you think of lawyers as the worst of the stereotype. So, ambulance chasers, greedy, selfish, willing to turn a blind eye to the fact that someone has committed an egregious crime in order to get them acquitted. One sided, argumentative, irrational. All of these terms do apply to lawyers. But because of the stereotype perpetuated by what I like to call TV attorneys, it gives the rest of us a bad name. So, for example, let's check out my friend Campbell Alexander and see how he serves to perpetuate this stereotype.
Dad, there's been an accident.
Are you going to be able to get by without Carl's paycheck?
I just don't know for sure, Dad. Everything seems so awful. I mean, what rights do we have? I guess I'll need a good lawyer.
Good just won't cut it. Not with 2 hungry mouths to feed. You need the best lawyer there is.
Sounds nice, Dad, but who?
Campbell Alexander's the man you need. With its 98% success rate, its reputation and dedication, I've won him thousands of cases.
Do you need your voice to be heard? Do you want justice to be served? You deserve a lawyer who takes your case seriously. And I'm serious when I say I won't back off until you get what's rightfully yours. Hi, I'm Campbell Alexander, and I'll fight for you.
When my father passed away, there was a big dispute over the will. I was left out in the cold. I really needed the money. Campbell Alexander helped get me the money I deserve. And now, I'm living the life I always dreamed of.
I gotta be honest with you. Over the years, I've helped thousands of clients win their cases. Not hundreds, thousands. That takes experience. Serious experience.
I was injured on the job. Can you get me a fast cash settlement?
Yes, I can.
I don't want to be deported. Can you help me to get my green card?
See, Joe Puedo.
I'm a victim of medical malpractice. Do I have a case?
Do I have a pen? Yes, I do. I'm Campbell Alexander, and I won't stand for injustice.
Wow.
He took my case seriously. He made it clear to me from the very beginning that I have rights.
He's very thorough, very efficient, and he gets the job done.
Every human being on God's green earth has rights. You have rights. Serious rights. When the law puts up a fight, I fight for you.
Thanks, Campbell Alexander.
Thank you, Campbell Alexander.
Gracias, Campbell Alexander.
When things are looking down,
Look me up. I'll go to great heights to get what you deserve. I'm Campbell Alexander, and I'll fight for you.
seriously.
Call 1-800-1-THE-LAW to speak with Campbell now. Operators are standing by.
Do you see what I mean? Now, I don't know if Campbell Alexander in that commercial, whether that's real. I mean, it says that he's sponsored by the American Civil Liberties Union, but I guess anyone could put that on a spoof video. However, what I do know is that the class of lawyers that he's representing do exist, and they give the profession a bad name. In turn, this causes members of society to form these stereotypes against lawyers. Here's one television commercial that was aired during a Super Bowl, and it's very real, and it makes Campbell Alexander seem tame.
Brian Wilson, Texas Law Hawk. Brian Wilson, the Texas Law Hawk.
Sorry.
Hounds of justice. Due process. Do wheelies. It's hot out here. Brian Wilson. El Halcon de la Ley. Brian Wilson, the Texas Law Hawk. Hey, guys. Well. It's no refusal weekend, so you have to blow. Otherwise, you're gonna lose your license. These things are 100% accurate. Blowing it. Surprise failed. Blow. Yeah, I don't think so. Someone just called me. That's why you don't blow. Brian Wilson, the Texas Law Hawk. You or a loved one been arrested? So call Brian Wilson, the Texas Law Hawk today.
Before I go back to Brian Wilson, here's another one. Again, aired during the Super Bowl.
I'm Jamie Casino. You may have seen some of my personal injury commercials on TV. I wasn't always a personal injury lawyer. I once was a notorious criminal defense lawyer who was employed by some of the most cold-hearted villains. My art brought me great wealth until one day my little brother Michael and his friend were 2 or 4 people whose lives were taken.
My brother was involved in a situation last night. He was shot. He didn't make it.
After the tragedy, our chief of police deceived you to make it look like the police department hadn't lost control.
No innocent people were targeted.
Daddy, what do you do when you go to work?
At some point, a man must ask why God created him.
Oh dear.
When you fall down on your knees, beg for mercy, Mr. Please. Time's come to let things right. And George will plead to you. We don't think you do.
What do you do when you go to work?
I'm attorney Jamie Casino, and I don't represent villains anymore. I speak for innocent victims who cannot speak for themselves.
So that did just happen, as well as Brian Wilson, the Texas Law Hawk. And you could fill a semester-long course with just cheesy attorney commercials. But what I do is try to get all of these stereotypes out of the way up front and share with you a few things.
Well, have you ever wondered what happens when you're out cold at the doctor's office? Well, one unsuspecting patient checked his smartphone after a routine procedure and discovered some nasty results that had nothing to do with his health. Here's ABC's Gio Benitez.
Listen closely.
Round and round we go, wheel of annoying patients we go. Where to land, nobody knows.
That's the voice of a doctor, anesthesiologist Tiffany Ingham, before a routine colonoscopy at a Northern Virginia hospital in April 2013. Her patient used his phone to record post-op instructions, but he says he did not press stop before he went under, unknowingly capturing Ingham's cringeworthy conversation.
And really, after 5 minutes of talking to you in pre-op, I wanted to punch you in the face and man you up a little bit.
I always pass out when I look at the screen.
Well, why are you looking then, retard?
The patient filing a lawsuit anonymously. He's identified only as DB in court documents, claiming medical malpractice, in part because of this false diagnosis.
I'm going to mark hemorrhoids, even though we don't see them and probably won't. I'm just going to take a shot in the dark.
and defamation because of comments like these.
Or irritation or something that none of us want to go look at. So just make sure you're down up. Don't want you to accidentally rub up against it. Some syphilis on your arm or something.
Last week, a judge ordering the anesthesiologist and her practice to pay the patient $500,000 in damages. She's no longer working at that Virginia hospital. In fact, we don't know if she's working anywhere now. Her attorney has not returned our calls for comment, but on that tape, even Dr. Ingham recognizes she may have gone too far.
I feel bad. I shouldn't be so mean.
For Nightline, I'm Chio Benitez in New York.
No, you shouldn't be so mean. And so, let me get this glaring light out of your face and put another screenshot up. Okay, great. Before I get to the historical origins of the law, I want to talk about the things you just saw. So, I introduced you to this negative stereotype of lawyers that is reinforced then by the communication that is done through marketing techniques and that sort of thing. However, doctors also have a stereotype, and their stereotype, traditionally, is that they are healers, that they are brilliant, that they make people's lives better and provide them with medication so they can function in a more appropriate or a more functional sort of way. And in the news story you just saw, what we had was a doctor who was bucking that stereotype. And who came to the rescue? But some attorneys. So I don't know what the pre-existing thoughts the anonymous DB, the plaintiff in that action, had regarding lawyers prior to him needing one. But I'd like to share this with you, that you won't realize the importance of a lawyer until you actually need one. Then they will be your best friend. And I'd also like to share with you that if you can follow along with this course and engage with the dialogue that I provide to you, supplemented by these prezzies and videos and other class attributes on the Blackboard site, you're not going to have to come into contact with lawyers nearly as much. I mean, if you look at their hourly rates, it's an average of about $250 per hour for legal services. So, two things going for you. Follow the philosophies we talk about, especially ones related to proactivity and the foreseeability of things. And when you do need an attorney, trust in them, that they will serve you in a way that has your best interests in mind as your advocate. But those stereotypes will always be there. I mean, you look at a joke from the movie Philadelphia, it was Tom Hanks and Denzel Washington exchanging dialogue. But basically, Tom Hanks says to Denzel, what do you call 10,000 lawyers chained together at the bottom of the ocean? A good start. So let's move on in our analysis of the law while being cognizant of the fact that these underlying issues are there. Now, okay, going back to something that you learned in Business 201, which is a prerequisite for this course. The law is primarily separated into one of two classifications. The first type of law is known as common law. Now, common law comes to America from Great Britain. So when we declared our independence from that nation following the Revolutionary War, we did decide to borrow some aspects of their governance, and common law was one of them. Now, common law essentially looks at fact patterns which come before judges, and none of the judges look like this anymore, but they used to. And the judges will see the fact pattern in front of them, look to precedent, which is previous decisions made by courts, and then under this doctrine known as stare decisis, they are bound to follow that precedent unless they can find some sort of distinguishing characteristic. So, let me give you an example. The common law dictates that a battery is accomplished by committing an offensive touching upon someone else that was intentional and it caused that person to be offended or harmed. That precedent has been present in common law for ages. However, over 200 years ago, we began to see cases that didn't fit quite within the mold of a battery. So, for example, a previous case involved an older woman who was gracious enough to watch a friend's grandson. The boy was 7 years old, and so he was staying in the woman's house. One day, the woman did something to upset the boy, and the boy sought to lash out. And so, when the woman went to sit down in a chair, the boy did the old pull the chair away thingy and pulled it out from under her. She fell onto her hip and sustained significant injuries. She then went on to sue the boy and claimed that he had committed a battery upon her by using the chair and the ground to commit the offensive touching. Now, when the court was faced with this fact pattern, they looked to precedent and found none. This becomes known as a matter of first impression before a court. So what courts are able to do is look at past precedent from different areas of the law to see if they can offer insight into how they should respond. Here, with there being no applicable precedent to the case of a 7-year-old boy committing a battery upon an adult, they looked to contract law and said to themselves, well, if the age of majority to enter into a contract has traditionally been 18 years of age or older under our precedent, then we feel that it is not applicable in this case to hold the young boy responsible for a battery because he couldn't form the requisite intent needed to do so. So once this was decided, any case that came before a court involving a minor committing a battery upon an adult set precedent that the action should be dismissed. I do hope that this makes sense to you, but common law deals with areas such as torts, contract law, agency principle law, master-servant relationships, and more, and we will discuss them as the semester goes on. The other type of law is known as civil law. Now, civil law comes from the first democracy, aka the Roman Empire. How this differs from common law is that governments traditionally decided that they would put what is permitted and what is forbidden into writings so that the people in society would be on notice of what is acceptable and what would be not acceptable or against the law. When we formed our republic, we decided to take this aspect of the law too. And so the first form of civil law that we have was the Magna Carta, but the most significant one would be the United States Constitution, the Bill of Rights, and subsequent laws pertaining to civil rights and the like. So civil law can be passed on the tri-governmental levels of federal, state, and local regulation. And then they are codified into something known as an act, which is an all-encompassing law, typically on a federal level. A code, another all-encompassing law, typically on a state level. And then these acts and codes contain things known as statutes, ordinances, or regulations. It's best to think of this as acts and codes being a paragraph or a full paper, and the statutes and ordinances being the sentences that make up those paragraphs or papers. Now, civil law traditionally modifies common law. So common law would be the default, and civil law can change it. In our previous case of a minor committing battery upon an adult, the common law dictates the minor cannot form the requisite intent to be held responsible for damages. However, in states like Michigan, we have civil laws on the books pertaining to minors committing intentional torts against others. To illustrate this point, I'll give you another example from my experience. One day I had a young boy walk into my office with his mother, and they told me a story of something that had occurred during school on the playground. The boy had apparently been playing soccer with other children when he and another student got into a fight. The other student, the aggressor in this case, kicked my client squarely in the genitals. And as a result of this trauma, for lack of a better term, the young boy's testicle swelled up as large as a mushmelon, and it had to be removed. Now, when we filed a lawsuit against the aggressor's parents, as well as the school for failure to properly supervise during recess, we didn't rely on common law notions of battery. Rather, we looked to civil law, and on Michigan's books, it indicates that if a minor causes harm to another in the form of a common law tort, here battery, then you may sue the minor's parents to recover damages. Now, understanding the whole issue with the minor being unable to form the requisite intent to commit a battery, the cap on damages in these aspects is $50,000. And so if you've ever wondered what the value of a testicle is in Michigan, if a minor causes its loss, it's capped at $50,000. One other point about civil law, and it's a point that is going to have special significance as we move on in a new presidential administration. Our Supreme Court is tasked with interpreting our laws. It cannot, due to separation of powers issues, create new law. However, this really boils down to how the justices interpret the law. So, for instance, if the Supreme Court is made up of originalist judges that form a majority, originalist actually means a more conservative view of the law. If the justices are interpretist in their view, and they make up a majority, you're now looking at a court that would tend to sway toward a more liberal interpretation of the law. Originalists believe that the law should stay affixed in the point in time in which it was created. Interpretists believe that as society changes, so does the law. And we must adapt to the norms and values that arise out of society's evolution. So an example to prove this point. If a state law prohibiting the use of assault weapons or implementing mandatory background checks to buy ammunition or anything pertaining to gun laws comes before the Supreme Court, the court will look to the Second Amendment, which gives our citizens the right to keep and bear arms. Now, that phrase, the right to keep and bear arms, is problematic for multiple reasons. Originalists look at it and say, if the founding fathers of our country said we have the right to keep and bear arms, then we have the right to keep and bear arms, and the government cannot infringe upon that. Interpretists, on the other hand, will look at the Second Amendment and say, at the time that this law was created, we're looking at in the late 1700s, early 1800s, the climate of that era of America, where muskets and bayonets and small, difficult pistols, difficult to load, that is, pistols were carried by citizens, or where cannons were commonplace. These weapons were all we had in terms of technology. But interpretist judges are going to say, look at how technology has affected things like weaponry. Could the Founding Fathers have ever envisioned that we would have nuclear capabilities? The capability to commit chemical warfare or biological warfare? Could they have ever imagined that we would have drones with the abilities to shoot lasers? The answer is probably and most likely, I'll lean with most likely, no. No, they had no idea. And so how are we to say that the original meaning of the Second Amendment is still applicable to today's society? Now, I'll leave it up to your discretion as to what side you deal with, but on every controversial area of the law that comes before the Supreme Court, these two means of interpreting the law come into play and are quite significant. So as an overview of something I know you went over in Business 201, here's our federal court system. We'll be focusing primarily on decisions made by the United States Supreme Court or opinions issued by the U.S. Court of Appeals or a district court. But starting next week, I'd like you to turn your attention to the very last item in this photo. We're going to begin discussing all of these federal administrative agencies that regulate you. We'll also look to the state court. I'm sorry I had to create a lame graph here because I could not find like a nice picturesque photo of Michigan Supreme Court with the layers of courts displayed. So this is what you get. But it really is the same sort of tiered system. So where questions of federal law or disputes between citizens of two different states would come before a federal court. Michigan deals primarily with disputes of Michigan residents against other Michigan residents, or challenges to Michigan law. Again, the tiered system has a Supreme Court, a Court of Appeals, and then circuit courts. And we will focus on decisions made by these branches as well. However, if you look to the right of your screen, the administrative agencies, we will be focusing on those beginning next week. And I hope to show you that while you're being regulated by the federal government on multiple levels, you'll also be regulated by the state on those same levels or additional ones. So how do businesses attempt to insulate themselves from liability? Well, this should give you a clue. Businesses love to put up signs warning consumers of all the things they can expect to encounter during a given activity and to ensure that that person then assumes the risk of their behavior. Now, some signs are overwhelming. Some signs cater to our common sense. Some signs have their meanings distorted. Other signs are reactionary. Some just look like this. And let me say, with regard to this sign, if it is in a condition of disrepair such as this, do you really want to use the safety ladder? Some signs are silly. This one concerns the well-being of animals as opposed to you. Some signs, at least internationally, may be more accurate than those here in the United States. So this one, I took a photo of it in Jamaica on a trip there, and I really enjoyed the fact that the stick figure was running, which is a more accurate portrayal than most nonchalant, casual stick figures seen on American signs. There are signs for every possible activity, listing every type of possible consequence. But many signs attempt to alert us to things that have occurred in the past. So for example, this sign at DTE Energy Music Theater indicates that you could snap your ankle in an animal hole or something else that may be present in the grass. Now, the only reason that this sign is so large and so green and so in your face with its exclamation point is because DTE likely had someone break their ankle in an animal hole. They faced a significant lawsuit in which they had to pay damages, and now this is the result. So when you see signs, try to think about, well, why are they there? Does the government make them so? Or did something else precipitate their presence? You'll notice on this side that alcohol is also prohibited in DTE's parking lot. If you've ever been to DTE, this is not enforced. And so therefore, if you're going to put up a sign prohibiting certain behaviors and hope to use that as a defense someday during litigation, then make sure that you're following through when people violate the activities you're trying to prohibit. Some signs are just confusing. What is this one telling us to do? I think this man is telling me to quit school. So you may want to stop this video right now and disenroll from your classes. No, that's not what you should do, and that's not what this sign was intended to do. It looks like Ben Mitchell here will help you quit smoking. And he has a school for that. But, wow, what a poor job of marketing. I'll leave you with a few more signs just to illustrate to you that you might want to begin looking for them. In fact, one of your first assignments is going to be to take pictures of signs that you see, whether it's around the city of Grand Rapids, on Grand Valley's campus, or elsewhere. No, nothing. I'd like to take 1 second and talk about this sign. Now, for those of you who may be unaware, last summer in Florida, Disney encountered a situation where a 2-year-old boy was wading in the water near this sign at dusk with his parents a reasonable distance away when an alligator came out of this body of water and attacked the boy, eventually leading in his death. Now, Disney was well aware that alligators, snakes, and other hazards were present in the marshes and bodies of water surrounding their resorts. However, they put this sign up, prohibiting simply swimming. Following this young boy's death, you now encounter a more appropriate warning sign. If you'd like, you can do a little research on the Disney case and post that on the discussion board. Ultimately, what I would like to accomplish through this lecture is that you begin to develop a more preventative mindset. We're talking about the difference between being reactive to something, i.e., trying to clean up after it, versus looking at what could occur that would be dangerous in any given situation, and taking steps to prevent it ahead of time, before it would happen. So in the Disney case, it certainly would have been proactive on their part to put the latter sign up next to the body of water. The fact that it only was posted after a young boy died is very reactive in nature. I'll give you a few examples of how this mindset can happen in your own life. So when you're driving, proactivity requires you to look at what could other drivers do that could cause an accident, and so you adjust your driving behavior accordingly. So if the weather is poor, the visibility is slim, poor, then you want to give yourself more space between you and the car in front of you. That's a proactive approach. You want to lessen your speed. These sorts of things assume, yes, the worst could happen, and here's what I'm trying to do to prevent it. One example from my own life is that I live across from a baseball field in Ada, Michigan. Now, this baseball field is typically used by an amateur traveling youth baseball league during the spring, summer, and early fall months. When we moved to our home, it was late fall and no baseball games were going on. But once March and April, May of the following year rolled around, that's when I realized a significant problem with the baseball field. and the road on which it was located. Thornapple River Drive has a speed limit in this area of not 25 miles an hour, not 35 miles an hour, but 45 miles an hour. During baseball games, cars line the side of the road as traffic attempts to navigate their presence. During the games, balls are fouled off of bats, and they fly in all sorts of directions, but most of the time, they fly into my yard. And so I have buckets upon buckets of baseballs in my garage. What became apparent to me, though, was that while the games were occurring and balls were being hit into my yard and parents weren't paying attention to maybe younger siblings, that the real possibility existed for a 4, 5, 6-year-old to decide that if Big Brother just fouled a ball off across the street into my yard, that they should go get it. This would create a sort of worst-case driver's ed video scenario, where the young child is trying to cross the road unaccompanied to retrieve the baseball with traffic approaching at 50 miles an hour. Understanding this dynamic, what I decided to do was contact the township officials and say, well, what can we do to get the speed limit lowered? To maybe prevent parking alongside of the road. Now, I was met with sort of asinine governmental responses, which do exist. In this case, I was told that because it was a county road, the sheriff's department for Kent County would need to do a speed study. A speed study are those signs that you see when you're driving that are gauging your speed. That's what they're used for. And so, in this case, they decided to conduct a speed study during a non-baseball game time and indicated they would set the new speed limit at what 80% of the traffic was going regardless of the current posting of speed limit. I was warned by township officials that doing this could actually increase the speed limit, since many people break the law and speed. Nonetheless, when the speed study came back at being a 50 mile an hour average, they kept it at 45 for me. I have been fighting with the township now for 2 years regarding this issue. And although I have not gotten that speed limit lowered yet, this is an example of me trying to be proactive with things. It's foreseeable that someone could get hurt, and so I'm trying to prevent it. Reactivity is going to be when a child is actually hit by a car. Then the speed limit will be lowered. I hope that this makes sense to you. In the employment context, the textbook gives you this poetic acronym of stemming the tide of litigation. And what we're looking at with your employees primarily relates to not only how you manage them, not only how you find them, but the entire course of human resources. Because as we'll find in a few weeks with master-servant relationships, agency-principal relationships, you may do all you can to be proactive in your own life, even in your own professional life. But if your employees are in any way defective in the following listed regards, they will be the reason that you get sued more so than anything you do. So the S of this STEM preventative philosophy is to select the right employee. This means looking at things like qualifications, doing criminal background checks, asking pertinent questions during job interviews, relating to their past experience. Possibly implementing a drug test. Anything you can do to vet new employees is better than doing nothing. Now, I don't mean with this picture to offend anyone who's ever worked for Wendy's, but I can tell just by the language on this sign that that employee was not properly motivated, maybe not properly selected, certainly not properly supervised during the actions of putting those letters on the sign. I'm going to give you a second to read this article. This is a classic story of a child. No, it's not about a child at all. Sorry. This is a classic story of an employee doing the right thing. But when I look at the fact pattern here and see that she was able to make a sound ethical decision based upon the circumstances, it leads me to believe that she was properly selected. When I look at not a lengthy article, but again, just this picture, I can tell that this employee was not properly selected, properly motivated, properly trained, or properly supervised. While this insubordinate person was out by the sign, arranging the letters in such a way, maybe having trouble spelling stupid, who knows what was going on inside of the gas station or on the property surrounding it. You may have had someone smoking too close to a gasoline pump, someone on their cell phone, someone inside of the store stealing items or inventory, a guest who has just slipped on the ice because the parking lot wasn't properly salted. All of these things could come into play simply because an employee is not paying attention because they don't care. The rise of social media has given employees like this an outlet to share their stupidity. The T and the E of the STEM acronym relate to training. Not only training your employees, but training yourself to learn from the mistakes your employees commit and implement new training programs so that those mistakes are not committed again. Now, this is certainly something that involves human resource management, so I will allow you to learn about that subject properly during HTM 343. The same is true for the M of the STEM acronym, management. You'll find all sorts of ways in which to motivate employees, whether that's through positive reinforcement, providing social outlets, providing recognition of achievement. Again, all human resources related things. But one thing I do know, and I'd like to share with you, is the following acronym: that pride is to apathy as safety is to negligence. Let me illustrate this with two recent cases. A few years back, a child and his mother and father went into a Steak and Shake. When the server came to take their order, the parents placed theirs, and then the child indicated he wanted some chili. And he told the server that he wanted hot sauce on the chili. And so the server sent the order back to the kitchen. And working that day was an employee who, for whatever reason, had just lost touch. And that employee, when they heard the order for hot sauce, decided to pull a bottle of Megadeth hot sauce out of a jacket that they had brought to work and pour it sparingly over the little boy's chili. Now, Megadeth hot sauce, for those of you who are not aficionados, is the type that must be diluted in water in order to make it consumable or safe. This was lost upon that employee, or perhaps not, and he was just a bit more sadistic. Either way, when the little boy was served the chili and he took a bite, his esophagus immediately became inflamed, necessitating a call to 911 and a lengthy trip to the hospital. The boy suffered severe and debilitating pain and suffering as a result of this employee's actions, and a lawsuit, of course, resulted. The theory was negligent supervision, negligent training, that management had not properly looked at this employee's work behavior at the time he was able to use this foreign substance on the boy's chili. In that case, this is an apathetic employee. An apathetic employee, or apathy, means that you're indifferent, that you don't care anymore, that you've checked out. And when an employee is apathetic for whatever reason, that is when negligence occurs. The second example I'll give you is out of my hometown of Toledo, Ohio. Again, a few years back, an employee had been fired from a big boy in Toledo and did not leave on the best terms. Now, he had been fired later in the day, in the evening, and so the following morning, really no one who had been working the night before was present. And although this employee had been terminated, he showed up to work, made his way back to where the coffee was being brewed for the guests and employees of the restaurant, and he pulled out a vial of a drug that is given to baby pigs for anemia. It helps the anemic pigs, but if consumed by humans, this drug is lethal. As this disgruntled employee was about to pour the contents of the vial into the brewing coffee, one employee who was not outside smoking a cigarette or on their cell phone during work hours or gossiping with colleagues. No, they were actually paying attention to the work environment, knew this gentleman had been fired, was able to approach him and detain him until police arrived. This employee, through that action, inherently has pride in their job. And when you have pride in the work that you do, you desire safety. You want to make sure that no one gets hurt. Not on your watch, at least. Because you know it reflects poorly upon your manager, upon your company, upon you. So when you have pride in your work, you're much more likely to be safe. I'm going to pause here and rejoin us in a second.